Hello and welcome to this webinar within the context of contributing to the health of conjugal violence survivors in family law. So today we're going to talk about obligations belonging to people in the legal system when it comes to family violence, spousal violence, and all of the rights associated with those. Before beginning, I'd like to recognize the territory that we are at. Think about the traditional territories, lands where you are, and join us in thanking the ancestors, Indigenous people who've taken care of these lands. We work together to be able to render more concrete truth and reconciliation and to give justice to women and girls as missing and murdered Indigenous women and girls. So in our deontology, our code of practice, we need to continue to recognize the violence as applied to women and girls and the different forms of violence. Next slide, please. Before beginning, all participants are on mute during the webinar. There will be a question and answer period at the end of the webinar for about 15 minutes. But during the presentation, we'll not take questions. There will be an assessment form that you can fill out once the webinar is over, and we'll send you a certificate of attendance. Slides are on our website, and there's a code of practice as well that will be in the discussion box. Our webinar here today is in French and English with simultaneous interpretation. So if you'd like to get translation, the webinar will happen in French primarily, but we have simultaneous interpretation, and you can ask your questions in English or in French, and all you have to do is click on the little globe written interpretation. You pick the language that you would like to listen in. It's the same thing for the slides. You can select either the French PowerPoint or the English PowerPoint, and then you can follow the presentation in that manner. So if you just need a few seconds to do that, then please take a moment to do that, and that's not a problem. And in a short while, we'll be able to continue with the next slide. Oh, we can skip that one. We can skip that slide. And now the presentation will be mainly given by Daphne B. Menard, who is with us here today, who worked with us on this project and has been working on this project for several months. She has done a lot of research upon which the webinar is based, and she will give her presentation based on the research that she has done. So basically, we're looking at codes of practice for the legal system. We will talk about what habitually judges and lawyers do, where the errors have been, and we'll finish the presentation with some best practices to implement in a file involving spousal and family violence. After that, we will take questions. Next slide, please. So before diving into more details in introduction, this presentation comes from a community of practice with people from different sectors. So intervention, legal system, lawyers, judges, family counselors, experts in family violence, youth protection agencies. And we've had a number of different communities of practice involved, but the question of codes of practice comes up again. Codes of practice for all those who need to be connected with women who are victims of domestic violence. And as a psychotherapist and psychologist, and all sorts of things. What are the professional codes of practice that we need to follow when we only are working with someone who is a victim of spousal violence or family violence, conjugal violence? And for people in the justice system, the question is, how can we converse? How can we talk about research, write it? What information is available on the program's website? And how can we ensure that today's webinar, so this is sort of a follow-up and an update of the summary that was in line last year, but it's a joint question. Today, we're looking at the legal professions within this context, but ultimately we're looking at interactions between all professional orders. Among all professional orders, please note that we will be looking at codes of practice as they exist in Quebec. And for judges, for example, you will see that this is something that's more Canadian, and there are definitely things that can be done, different interactions between the different Canadian provinces and that sort of thing. So just a reminder, there's an act on divorce, which includes family violence. And the question that we wondered was, for people who are involved in the justice system, are they able to identify locations where there are different applications, and are people specifically trained to be able to address questions of family violence? Next slide. And why is this an important challenge? Well, because people play a key role in the update, the prevention, the protection, the risk factors, interfamilial connections, and any form of physical, psychological, or mental violence. And to offer good legal services, we have to be able to identify all of the questions around family law, including all the questions that could come from conjugal violence. And the last point is that as the member of a legal professional order, we are held to a code of practice which obliges us to take into consideration all of these questions for the most part. And Daphne will take the floor, and she will present the how and the why in the next few minutes. Thank you, Dominique. Next slide, please. So we're going to continue with this first portion, which is code of practice obligations, as Dominique was saying. So specifically people who work in the legal system in Quebec already. So we're talking about lawyers, notaries, mediators, and judges in Quebec. And this is specifically when it comes to competencies, training, and understanding conjugal violence for these people. Next slide, please. Let's begin with lawyers. By virtue of the code of practice for lawyers, lawyers have obligations. There are duties to their clients and there are duties to the file, but those are general. So what we'll see is we'll take a look at a few things. So lawyers must constantly act in the best interest of their client, and they have duties and obligations in competencies and quality of services rendered. So lawyers need to be professionally competent, and to do that, they need to develop and keep their knowledge and their abilities up to date. Specifically, a lawyer in Quebec needs to do continuous training, so including 30 training hours over a reference period of 2 years. So 3 years of those 30 hours need to involve ethics and codes of practice and professional practice. More specifically, when it comes to mandates, the lawyer needs to always take into consideration the limits of their competencies when it comes to the sector of law that we're talking about, and professional activities, the nature of professional activities required. Now, there when a lawyer is able to exercise their mandate, or when they can't, they can act with other or do work with colleagues. If they assume that the limitations draw a limit for clients, they have to advise their clients and advise the client on how they can move forward, so that it be a clear decision, and so that the work actually get done. If the mandate is undertaken despite the limitations, then we will move forward and ensure that the mandate be implied adequately. If we feel like somebody does not have the competencies to continue to work, then the lawyer needs to stop working on behalf of the client. Next slide. So we understand that in Quebec, what we've seen is pretty general. There's nothing very specific around spousal violence. So family lawyers don't have any obligation to take training in this. Yes, they do need to understand how to detect conjugal violence in their clients, but essentially this is pretty general. There's nothing very specific for spousal violence for family lawyers. However, what we do have is, there was a committee of experts on accompaniment, victims of conjugal violence, people who are involved. There was a report in 2020, and one of the recommendations that was implemented meant that we would create a bank or a booklet of all of the lawyers specialized in sexual and conjugal violence. So lawyers on this list, the names of lawyers on this list, and the link is in the slide if you'd like to go and see this list, they have all had conjugal violence training. And that training is financed by the Ministry of Justice in Quebec and delivered for free for lawyers who are interested in following this type of training. So any client, a victim of conjugal violence, anyone who's looking for legal services and who would like to get someone who is specialized in conjugal violence, for example, well, at that point, we have the opportunity to find someone who is available in their region as well. So that's what's in place, and that is what exists in Quebec, even though there is no obligation, like I was saying, for lawyers. Next slide, please. Let's talk about notaries now. This is a specific thing in Quebec. Notaries can also work with separating couples and work through some of the legal steps with them. So, for example, child custody, pensions, etc. And some conditions can come up. A notary, in some cases, can also represent a spouse before the court, before a judge. That's a little exceptional. Normally, it's lawyers who do that type of work, but this is an option. It is a possibility, and some notaries do that. Even though, it's a little bit more marginal, but it happens. So I want to mention that today. Once again, in terms of the code of practice for notaries, these are obligations that are general. They are obligations around competencies and training and updating their knowledge and understanding the development where we enact our profession. And again, like the lawyer has no specific codes of practice specific to training, but so that's a little bit unfortunate. There's no obligation to focus specifically on spousal violence. Now, let's talk about mediation, family mediation. In Quebec, family mediators come from different professions. So it could be a lawyer, could be a notary, but it could also be a social worker, a spousal therapist, psychoeducators, guidance counselors, etc. There are lots of people who can do this work. Each person needs to respect their own code of practice and the best practices associated with their profession as well. And since codes of practice from various groups do not necessarily have any provisions applying to violence, conjugal violence, and spousal violence, well, there is what we call the Committee of Accredited Organizations for Family Mediation. It's what we call the CYMF in French, COAMF, sorry. And what they've done is they've defined a common code of practice to define a certain level, a certain standard when it comes to quality of services as rendered in family mediation in Quebec. And these standards are in a guide. We have a link there. It's the standards of practice for family mediation. It's a guide. It has a whole section on spousal violence and the obligations of a mediator when there is a case of spousal violence. Now, we do have to note that this guide, this standard, the standards guide, it does not have legal weight. It was adopted by the National Assembly, but not in the same way as other codes of practice. It's more a self-regulation approach specific to the sectors and to family law. But what's interesting, as I said, is that this guide has a is fully applied to spousal violence and has a lot of information. Next slide, please. So the guide, as we said, is very specific. It's very interesting, and it indicates to us that there is a guiding principle which needs to be maintained throughout and which allows us to follow files. The principle is to ensure the physical and psychological health of every person throughout the entire process. So that's the basic principle. And that's where mediators need to start to work. And there is also, sorry about that, there's the idea of behaving competently. And that is specifically stated when it comes to conjugal violence challenges. When we act, it allows the capacity to identify the problem and any appropriate intervention. And the mediator also needs to suspend or apply an end to the mediation if spousal violence continues, and if the abused person or the abuser cannot negotiate face-to-face respectfully. So at that point, we have to stop mediation. So that's for mediator competencies. Now, we also have some specifications when it comes to screening. The family mediator needs to understand two tools or two means to recognize or distinguish the conjugal violence from other strategies or other conflicts that are interfamilial. And in any new file, the mediator does need to do what they have to do to differentiate between the dynamics that they're confronted with, amongst other things, family violence. And this screening needs to happen not only with every new file, but along the way throughout the entire mediation process. So it's really interesting. Next slide, please. Like I said, this is a self-regulation guide. So it's not an act or a bylaw, but based on bylaws around family mediation. In Quebec, again, we have accreditation, supervision, rating in family mediation as supported by or funded by the government. In this case, mediators have the obligation to pick up a certification with training, including at least 6 hours of awareness raising when violence is in the picture. Family violence, spousal violence specifically. So we have a regulation around that. And the Civil Code, Section 417, we have the possibility of someone who confirms that they are offering services to recognize victims by the Ministry of Justice. If someone indicates that they're a victim of family violence, they can be exempt from participating In Quebec, we have an information session on family mediation, and it's obligatory, it's mandatory for all those who are part of the legal system. We have to inform the people of the possibility of family mediation, but if we are a victim of conjugal violence, we are exempt from this. And so it's interesting. Next slide, please. Thank you. Let's talk about judges now. Judges are clearly very important players in the legal system. And by virtue of the code of practice and for judges and the codes of practice for municipal judges, the judge has the obligation to maintain their professional competencies. A judge needs to manifest the fact that they are impartial and objective, and the judge must also preserve the integrity and defend the independence of judges in society. This has been added in what's been added in Quebec, and this is specifically for sexual and family violence. There's an obligation to follow a new program for improvement around sexual and conjugal violence for any person who is a candidate to being a judge or a justice of the peace. So we do know that this is for new judges, so judges who are candidates, and they must continue to do this. They must do this improvement program if they are selected. So that's for new judges, but what's interesting is that it's not linked to this new specialized division when it comes to sexual and family violence. So that's anybody who acts as a judge, a justice of the peace, any otherwise judiciary, and who is involved in these types of processes. Next slide. Is a judge on the federal level, and perhaps you've heard this, but last week, so it's extremely hot off the press, there's a bill 233, C-233 was adopted, was tabled on Wednesday. It's the CARA law. And CARA anticipates a modification to the federal law on judiciaries when it comes to specific information regarding intimate partner violence and coercive behaviors around family members. And these are federal judges. However, in this bill, there's a section that was not modified subsequently to state that training should also be in place when it comes to myths and stereotypes against people who complain about family violence and intimate partner violence. And so now, to my knowledge, none of this information was adjusted for the training on family violence, unfortunately. And section 3B concerning the nomination, that's not clearly associated with that information either. So it's recent, it's new, and it really carries some weight for federal judges. It's really important. Next slide, please. Okay, so when we talk about advantages for judges, it's training. When it comes to screening, there's no informal obligation to systematically find a specific case of violence for each judiciary or for somebody who goes before the judge. In Quebec, however, when there's an issue around family violence, Section 420 of the Code of Civil Procedure says that when a court imagines stopping a trial or something to allow a party to undertake family mediation, well, at that point, the court needs to take into consideration, amongst other things, the existence or the application of family violence before starting mediation. So they have that obligation at that time, but not in every case. Next slide, Steve, please. Now, a couple of other or a handful of other people who are involved in the legal system. I talked to you about the Specialized Tribunal for Sexual and Family Violence in Quebec, and in that context, there was information for judges, but there's also the addition of continuous training on realities relative to sexual violence and spousal violence for those who are susceptible to intervening in this specialized court. So we're talking about lawyers, defense lawyers, prosecutors, clerks, anyone in the court, interpreters as well, who could find themselves before the court. Researchers and police officers, social workers, and social participants. So contrary to what we said earlier about judges, this training for every other stakeholder knows that those who will be susceptible to intervene in this new division for the criminal and penal court, I mean, you can understand that these are not necessarily stakeholders who work in family law, because like I said, this is a criminal and penal court division. So people in that division and not necessarily associated with other approaches in the room. So next slide. What we've determined here, if we give ourselves a conclusion, if we look at everything that we've seen in terms of the different players, what we've determined is that lawyers and notaries do not have an obligation. Well, they only have general obligations when it comes to competencies and training. It's not specifically associated with conjugal violence, whereas judges will benefit from mandatory training for sexual and spousal violence. Family mediators, what's interesting with them is that there is training that we saw. It's part of the certification. And there are standards of practice as well. Those are guidelines, but they were also very concrete, very specific when it came to understanding that there was conjugal violence, intimate partner violence, and then steering the files. So these are guidelines that could be inspiring. We can be inspired by them for other professions as well. So lawyers and notaries. So essentially, that is what is anticipated in text, but it will see what happens in practice. Next slide. In this next portion, we wonder what are the practices that are currently implemented when it comes to training and screening by legal stakeholders. Next slide, please. Specifically, there isn't a whole lot of data, specifically in terms of Quebec. So we have Canadian data, and it's specifically for judges and lawyers who work in family law. So not necessarily other stakeholders, but essentially the data that we have, this is the data that we have in part. So first of all, in 2016, there was a national survey that was done with practitioners and, well, family practitioners and family law practitioners to understand their practices. In the survey, we realized that more than two-thirds of lawyers, 69%, declared that they always attempt to understand if there's conjugal violence, compared to half of judges. So there's a certain level of detection that is done, screening that is done, but it's not for every single lawyer. And what we've determined is that judges do it even less than lawyers do. More than half of lawyers, 53%, said that they never used any other measures or standardized instruments to detect conjugal violence, and 25% of them have rarely done it. So if we accumulate, there's a 75% of lawyers who do not use a systematic tool. So I imagine that happens, that is done more or less intuitively or organically. That's what we're determined when we see certain bits of evidence in a file, or we hear from a client, the client says, okay, well, maybe there will be some flags, but there's no sort of use of standardized file each time.
And finally, this survey shows that on average, lawyers said that family violence is a problem in 21.7% of their cases, and judges said that it was the case in 25.3%. So about 1 out of every 5 or 1 out of 4 cases, and so this is quite a significant volume. And this means that given this volume, there needs to be screening using a standardized tool in order to screen for family violence. This needs to be done by lawyers and judges, and also among other legal practitioners. Next slide. There was another research project done in BC more recently, and it has to do with the question of family violence in the family justice system. Part of this research was to consult lawyers who specialize in this area in order to understand their experience with the fact that a specific consideration for a specific training for family violence was added to the Family Law Act. So how or what has been the effect of this addition on the practice? And there weren't it wasn't a huge number of people that were surveyed, but of these 18 lawyers who were surveyed to find out whether they had had specific training on family violence, 8 out of 18 of them, 44%, said that they had not received specific training on family violence, despite the inclusion, as I said, of a specific consideration for family violence in the Family Law Act. So, without training, can one really be able to take into consideration this addition to the Family Law Act? This is something that needs to be taken into consideration. Next slide. So clearly there's a lack of training among lawyers and among judges in terms of family violence. There's also a lack of screening using standardized tools. But beyond these technical competencies on family violence, there's also a lack of know-how among lawyers in terms of the way to support those who are victims of family violence. This study also had focus groups. There were also interviews done with survivors of family violence, as well as people who were before the courts, survivors in the area of the family court system. And we asked them what their experience was like with their lawyers. And unfortunately, many women mentioned negative experiences that they had had with their lawyers. And something that came up very often was the idea of feeling rushed by their lawyers. They also felt that they weren't being taken seriously. And they also had the impression that their lawyer was not the right person to disclose things to. They didn't feel comfortable talking to them about these experiences. So this emphasizes the importance of lawyers having this type of knowledge. Next slide. So this report was interesting. It also mentioned the importance of training among legal practitioners in order to dispel myths and eliminate stereotypes with respect to victims of family violence. These prejudices and myths mean that sometimes within the legal system, their experiences are ignored because of these myths and these stereotypes. And of course, it's necessary to dispel these myths and stereotypes in order to reestablish public trust, especially survivors of family violence, with respect to the legal system. So in law, reasoning based on myths and stereotypes is erroneous in nature. This can bring about miscarriage of justice, and it can also possibly be considered an ethical lapse. So in terms of this type of judicial error or miscarriage of justice, this is the case if illegal reasoning that is conjectural in nature is used, and if stereotypes are used with respect to the behavior of the victims of family violence, and this may have a material effect on the analysis of evidence and on the verdict. So in terms of family violence, the only types of myths and stereotypes which are currently condemned are the ones that have to do with the behavior of an expected victim. This myth, according to which a woman who continues having a relationship with her abuser is not really a victim of family violence. So a woman should quickly and easily leave a violent partner and not have any more contact with them. This is a myth that has been condemned in Canada since a Supreme Court ruling. So in the case of a judicial error of this nature, speaking about such stereotypes and myths may also be a form of ethical misconduct. So the trust of the person who is before the court, has this trust been undermined? Has the integrity and the impartiality of the judge been undermined? And this argument could also be made in terms of family violence and this particular condemned stereotype. So if these types of stereotypes and myths are used, and if this is considered a judicial error, it should also be considered an ethical misconduct, because this undermines the appearance of impartiality of the judiciary. However, as far as we know, there has never been a legal ruling in terms of ethics with respect to a judge. So there have been no particular rulings of this nature. And what you need to understand is that this myth of the so-called normal behavior of a victim of family violence, this is a myth which can bring about an undermined legal reasoning in criminal law, and more so than in family law. So it may be that there are other myths and stereotypes aside from those that were brought up by Hirmek and Hawkins in 2021. Other myths, for example, the idea that women exaggerate the violence that they experience, or the idea that women who argue that the father should not be entitled to parenting time do so out of revenge. These myths may bring about a type of reasoning in criminal law which should be condemned in the Canadian legal system, and specifically in the area of family law. As for lawyers, the same principles should apply. So if it can be seen as a judicial error, should it not also be seen as a form of ethical misconduct? For example, in the case of a lawyer who is doing a cross-examination and who is perpetuating these types of myths and stereotypes, and if the lawyer is supposed to uphold the justice system and promote public trust within the justice system, this in the case of this type of behavior, this should be considered a misconduct by the lawyer if the lawyer is perpetuating this type of stereotype or myth, which, if it is used to support the reasoning, is considered ethical misconduct. So there haven't been any disciplinary decisions made with respect to a lawyer and these stereotypes and myths. However, these questions are important, and they should be researched further so as to broaden our knowledge of the subject. Next slide, please. So we will now move to the last part of the presentation, which has to do with the best practices required in cases involving family violence. So as we await further legislative reform in order to better take into consideration family violence, for example, mandatory training, of course, we encourage legal practitioners to be proactive and to learn about these things. There are quite a number of tools that are available. We'll just talk about a few. There are many others. And these practices, of course, need to be fine-tuned according to the particular situation. So, educating oneself about family violence, deconstructing prejudices believing victims of family violence, and developing know-how. We have an information kit, which was prepared by the INSP. And this is a good starting point for anyone who is not familiar with the question of family violence. It addresses myths and prejudices about family violence. And it also addresses risk factors, the consequences of family violence, various statistics on the subject. So it's an excellent tool. It's easy to use, and it's available online. The first step, of course, is to take the time to listen to those who are victims. And so there don't need necessarily to be any amendments to, say, the Family Law Act. And of course, the legal process can have significant consequences on the victim. There can be a secondary victimization. The person may be forced to be in contact with their abuser, for example, in the courthouse. And they may want to protect their children from the abuser. So this requires empathy, listening to the victim, and this is necessary for lawyers as well as judges, mediators. You need to have a certain degree of interpersonal skills in order to cultivate these abilities. And a guide was recently published by the Quebec Bar Association, and it has to do with the context of examination and cross-examinations, but it's very interesting because it contains recommended best practices with respect to lawyers' know-how and also interpersonal skills among lawyers in the context of examinations and cross-examinations, because these are moments that can be quite difficult for victims of family violence. So this guide was published by the Quebec Bar Association. Next slide. Another important thing is screening for family violence in every case. Clients won't always reveal from the outset that they were or continue to be victims of family violence. Simply, they may feel uncomfortable with their lawyer, and they may fear the consequences. They may feel shame for having been a victim of family violence. So these victims may not necessarily want to talk about it, and this is why it's necessary to screen every new client using a two-step approach. First of all, a short tool can be used in order to identify what we might call red flags or signs of family violence. And so if there are red flags or these signs, or if the client has directly brought up the fact that they're a victim of family violence, we can move on to the next tool, which is a little bit more specific and allows us to better understand the whole situation and understand what we're dealing with. Of course, the screening should be done in person, in a confidential environment and a safe environment. And it should be done during the initial meeting with the client. And as we saw in the Family Mediator Guide, the screening process should be seen as a continuous process which occurs throughout the case. Because, of course, the situation of the client will change in terms of risk factors, in terms of how dangerous the situation is. So everything constantly changes, so the screening must continue throughout the case. And there are a number of tools in order to screen for family violence. And in Appendix B, there's a tool from the report What You Don't Know Can't Hurt You, the importance of family violence screening tools for family law practitioners. It's very specific, so we would invite you to consult it. Next slide. And finally, another best practice is to verify the minutes book and other civil or criminal procedures or in order to really understand the entire situation of what's happening before the court. Next slide. So if a situation of family violence is screened for, the level of danger must be evaluated and a safety plan must be developed for victims. So there are other tools which allow us to assess the level of danger. And during the introduction, we spoke a bit about it. The context of divorce is a risk factor identified by the literature. So in the case of a separation, women are more at risk of serious injury, of psychological violence, etc. So this is a unique moment in the context of separation. So the level of danger needs to be taken into consideration, and there are legal tools that can be used in order to make the family a little bit safer. For example, there are protection orders according to Section 509. There are orders to keep the peace. And in terms of parenting time, in terms of shared custody, this is what's normally prioritized. However, it may be that the abusing parent may need to be necessary to take into consideration the best interest of the child. And so in the case of abuse, this may mean that the child's safety is undermined. So what's necessary is to consider the possibility of sole custody, assuming it's necessary for the best interest of the child. There's also the question of supervision of access rights, supervised custody exchanges, or supervised visits. This may provide a safe and neutral environment for the child and or parent. There's also the ISA protocol, which involves the use of an alarm system. The principle is very simple. It will enhance the safety of the woman who's a victim of family violence by giving her access to an alarm system. But this system is not available throughout Quebec, and there's certain eligibility requirements. So it all depends on the region you're in. And finally, don't forget that many professionals, including lawyers and notaries, are allowed to violate professional secrecy or communicate confidential information in order to prevent an act of violence, including a suicide, where there is an imminent danger of death or serious bodily injury to a person or a group of persons. So, if there's such a possibility, it must be reported. Next slide. Finally, using specialized organizations. We've spoken about legal practitioners, but of course they have expertise in the area of law, and so they simply have only skills in this particular area. They're not social workers. However, there are many organizations that we can refer victims and clients to, whether it's the abuser or the victim. They can be referred to these organizations who specialize in the area of family violence. And as legal practitioners, we can also refer ourselves to these resources if we want to have more information or more things to think about in terms of how to support our clients in these types of situations. So we just given you a few. There's SOS Violence Conjugale, which is a phone line which provides psychological support, immediate interventions, and referral to women's shelters. There are the CAVACs, which are available throughout Quebec, and they are crime victims assistance centers. There are various types of women's shelters, including the Fédération des Maisons d'Hébergement pour Femmes, which provides housing to women who are victims of family violence. And finally, Accord d'Âme, which offers services and follow-up services to help violent male partners and fathers take responsibility and to try to change their behavior. So there are many organizations, and in other regions there are additional organizations. And so it's good to have an inventory of these resources in order to refer our clients to these services. Next slide. So finally, we've provided you with a list. These are some other tools which allow us to better understand family violence in the context of family law. So there's the Help Toolkit, a lawyer's guide to keeping women and children safe in BC's family law system, best practices for representing clients in family violence cases, advice for the family law practitioner representing a woman leaving an abusive relationship. So all of these things are available. You can simply click on the links and they'll help you better understand this type of situation, and it will allow us to better equip ourselves. And in Quebec, there's free training offered on family violence and post-separation situations, which is provided to legal practitioners who are interested in developing their skills and developing strategies to better support people who are victims. So it's a good idea to check out this training. Next slide. Finally, in terms of the current research project, the project is continuing, and from awareness to action, And the next part of the project's goal is to develop a Canadian guide which will allow us to identify the various types of family violence, as well as to describe the impact of that violence on survivors and on their children. And it's also to develop parenting plans that account for those impacts and address ongoing risks and keep families safer. So this is an additional tool that will be developed and which will allow us to better support people, including legal practitioners. Next slide. So we're at the conclusion. Dominique, would you like to conclude or should I? Yes, I'm back. I would just like to say a few things by way of conclusion. Yes, legislative reforms have allowed us to better understand family violence in the area of family law. But in Quebec, some areas of reform in family law have not yet taken into consideration family violence, as has been recommended. For effective implementation of new provisions, it's necessary to improve training among legal practitioners. And family law lawyers aren't obliged to take any kind of training on screening or family violence. And we believe this should be the case. So we should continue focusing on training and awareness raising so as to avoid legal reasoning based on myths and prejudices. And we'd like to avoid any instances of miscarriage of justice or ethical misconduct. And as Daphne just said over the last few minutes, the first step is to believe women and to not discount their experience or to silence them. And I'd also like to add one other thing. Sometimes we need to go beyond what's told to us, and these screening tools can help because some types of violence, for example, economic violence, can be very hard to identify if we don't have the right tools to identify them. So, Katya, I'll pass the floor to you for our question period, should there be any questions. Thank you. Thank you very much for this very interesting presentation. So, we've got some time for questions. So, don't hesitate to ask your questions. You can also send your questions through the chat or through the Q&A. Okay, well, it is 12:30, so don't hesitate to ask any questions, and this webinar will be available, so you can share it or listen to it again. Yes, this is one of the questions that was asked. That is to say, will the PowerPoint be available? And the answer is yes. Does anyone have any other questions? Well, I have a question, so I guess I'll take this opportunity to ask it. At the current time, there's no mandatory training, but I'd be curious to know whether you know whether this is something that's been studied. That is to say, could this training or screening become a norm or perhaps mandatory, something a little bit more formal in the future? Do you have any information on that? Because this is something that was mentioned that is quite important.
Dominique, would you have an answer to this question? I don't know if that was clear in the presentation, but there's nothing mandatory. It's more for lawyers, notaries, but we know that for judges, there were more and more. Last week with the new bill C-233 for federal judges, and we've got some information for judges, but for other stakeholders, it would be important. In Quebec currently, there is a family law reform process undergoing, and it's a big reform. So we would like to add this obligation to these reforms, so that family lawyers need to consider family violence in a file as it's currently present in the Divorce Act, federally speaking. Dominique, do you have anything else to add? Well, I can also say that there are lots of organizations stating that they want this law to be mandatory with specialized training to help jurists be trained, legal specialists be trained. So we do have some issues there. And then there's the codes of practice side of things, because people will do things when they have to. So I guess it's more this code of practice perspective to add this into the code of practice and have a much more clear guidelines around how to work with victims of domestic violence. Thank you. We have a question in the chat, so let me just read it to here. So this one's in English. Should I read the question in English? Is the other one the same question, actually? Yes, after there's another question, indeed. There is another question after that. There are a couple of them, actually. We've got 4 questions. I was going to start with the first one. Well, with regards to interprofessional collaboration, I think that's the goal of the research project that was presented at the end of this webinar. I think there are a couple of organizations and provinces that have already begun to work on this in an interprofessional way. Professional groups have their own limits, but when we collaborate and find common language, that is actually the best way of ensuring more successful collaboration. Okay, great, thank you. Now we have another question here. That's an interesting question. We have the challenge of someone who's in danger, imminent danger for their safety. Codes of practice already oblige in intervention. I think for other professions, we already anticipate that as well. Now, does it need to be mentioned first and foremost? I don't really have a clear answer to that question, but I do believe that indeed someone who does not have training in conjugal violence and spousal violence, family violence, then they could recommend that somebody else who has training take over that aspect of the file. Okay, we have another question. Yeah, well, we didn't talk about imposing a specific way of working, but if we're talking about a sector where there's no code of practice, we have suggested some ideas. If we have people victims of family violence, then we want to help that, but we don't impose a method as such. Some approaches, such as screening or detection, that's important. And most of the bar associations in Canada oblige family violence training yearly. In Quebec, we have 2 years, and it's similar for the Chamber of Notaries. I don't remember how many hours are there though. So things that could happen continuously and things that are constantly in line with new studies, like recent jurisprudence, for example, then that's one thing. But the goal is not to have just one single way of working. We want to be able to have a much more practice-based intervention. Okay, great. Thank you very much. Okay, so I'm not seeing any other questions. Okay, I saw a big thank you very much. That's great. Thank you. I don't see any other questions so far. I will be putting a link in the chat for the webinar assessment. And you'll be able to listen to this webinar. Thank you to all participants and to our panelists. Thank you for giving us such interesting information. So what I'm going to do is I'm going to put the link into the chat box. And I hope that everybody has access to this. So please let me know if you don't, for whatever reason. Thank you. Thank you to all of you. Dominique, I don't know if you have a few concluding words that you'd like to share with the group. No, just a thank you. Yes, thank you. Oh, okay. We have one last comment. Thank you very much for this information seminar. I recommend that too. Thank you very much.